Well, that's the matter we're considering just about now. We did see last week the papers awash with stories of the CJN summoning the six chief judges of 6 different states to Abuja. We understand that the meeting was supposed to have held yesterday and did hold, even though cameras were not able to catch anything. But it would seem that there have been some talk about what emanated from that. But that has been of very strong concern, as you can see, to the INEC chairman right there, talking about how conflicting ex parte orders has made their work very difficult, reminding all stakeholders that their work at INEC is not just as umpire, but also as a regulator of what is happening within political parties. So what can the CJN do? We see this morning that there are reports of how 3 judges are now to face disciplinary action or are to show cause why disciplinary action should not be taken against them for the slew of conflicting orders which you have seen coming from courts in recent times. One of them, Rivers and Kebbi, case in point, with regards to the removal of the chairman of the PDP. We've also seen a case in point, that of APGA. Today they have a candidate, they don't have a candidate, you know. We've seen all manner of situations, even with regards to the PDP candidate in the forthcoming Anambra elections. That has now been cleared up. But these are some of the matters in which we have seen conflicting ex parte orders. To weigh in on the matter as to what is the expectation of not just lawyers, but also of stakeholders within the judiciary, and also, by extension, the expectations of Nigerians. We have with us this morning Mr. Paul Harris Ogbole, who is a senior advocate of Nigeria. You're welcome to Sunrise Today this morning.
Thank you very much, Maswa.
First, let me ask you, were you happy when you heard about the intervention of the Chief Justice of Nigeria into this issue, this very thorny issue of conflicting ex parte orders?
Thank you. I was quite very elated. I was happy that the CJN waded into the matter to bring sanity and, decorum to the judiciary.
Was it of grave concern to you?
Personally, yes, it was. And I figure most lawyers felt quite concerned because it affects the integrity of the judiciary, which can, again, negatively also affect the democratic process we have. Because the judiciary, like we always say, is the last hope of the common man. And when there is, we're hearing discordant tones from the sanctuary, the judiciary, it leaves for confusion, and people are confounded. They don't know what is right or what is wrong. You're moving this way, you intend to abide by this order of court, then there's a conflicting order on the other side, and then you go back and forth. It's total anarchy. So what the CJN has done is to try to rein in the process and ensure that there's sanity and stability. He's empowered under the National Judicial Council Act, to call in discipline and set regulations concerning the administration of justice. The internal mechanism for cohesion and order within the judiciary. So he has exercised that power by calling in the heads of court, the respective courts, the states that are affected from where these orders came. He has called them first to hear from them, and the next step is a panel which will look into the records or proceedings of the court and all that happened, so that they also will have a fair hearing. A proper understanding of what transpired will be looked at, and then from there, and I think an appropriate decision will be taken by the CJN or the appropriate committee.
Well, we heard he wasn't alone at that meeting yesterday, that he was there with the President of the Court of Appeal and also the head of the High Court and also the head of the Industrial Court. The meeting which was held yesterday, we're not privy to it, and there are no camera shots from it, but these are things that we heard. And we also heard that there was a strong grilling of the judges, the chief judges who were invited, because from what we understand, he believes that the chief judges should bear vicarious liability for what has happened in their state. Do you agree with him?
Well, first, most of the judges you mentioned are naturally members of the Judicial, the NJC. And much as we do not know what transpired, as it were, it is to be expected that just the same way, the citizenry and lawyers particularly feel peeved about the conflicting orders of court under the circumstances. I do expect that the CJN, of course, the first line of hierarchy is administrative hierarchy in the state is the chief judges of the respective states. So yes, it is appropriate that he calls and hears from them and demands an explanation what happened, first from them. And yes, it is expected also that as the heads of court, they are supposed to man their courts and maintain, the sanctity of the respective judiciaries in their states. So I think what he has done is quite in order.
So should they have done this by themselves? Because, I mean, some people will say if a judge in Rivers State gave an ex parte order and another in Kebbi gave another one conflicting with what was given in Rivers, what powers will, say, the chief judge in Rivers State have over, say, a matter in Kebbi, for instance?
No, the chief judge of a particular state, his powers are first of all to assign the cases. He will assign the cases, and then the judge to whom the case is assigned will he's the arbiter in that particular case. So ideally, he would answer himself.
Do ex parte orders go through the chief judges? Are they assigned as well?
In most cases, they come to the chief judge. But if they are in divisions where there is a sole judge, if there is a division maybe on the outskirts, and that division, the matter comes up before that division, the judge can hear it without it having to go to the CJ. And then again, you have instances where there are vacation courts. There's a vacation judge. Because of the nature of urgency of these ex parte orders, it doesn't necessarily have to go through, maybe wait until maybe the regular courts resume and what have you. No, it can go straight to the vacation judge.
The point I'm trying to make is, do the chief judges really bear vicarious liability for ex parte orders?
Not necessarily. I do not think so.
And what powers would they have been able to exercise if it's out of their jurisdiction, so to speak?
Well, first, they do not bear the vicarious liability of judgments or orders of judges within their jurisdiction. That, let's be clear on that. However, for administrative lapses, where there are administrative, because he's the chief administrative officer of the judiciary in his state. So there are certain powers, certain administrative powers that he will wield, apart from assigning cases, but if there are disciplinary matters, he could make recommendations. And then he can also, set a stage, create, he's the head there. So as a head, whatever is expected of him to do as a head, he has to do. But as far as the particular case for which a judge adjudicates is concerned, no, he doesn't bear liability for that.
No, what I'm saying is, what if it's out of his jurisdiction? Now, out of his state, for instance.
Now, what happens is, when you have an ex parte order in a particular case, for instance, one emanates in say, Anambra, and then another one emanates in Kebbi. Now, the judge, the lawyer or the applicants who prepare the applications before a judge oftentimes may not disclose what is going on or the other facts of a matter that are already before another court. Yes, maybe if it becomes public knowledge, it may be a notorious fact for which a court may take cognizance of. But in most cases, the applicants will not disclose to say, look, there is a similar application before another court. An order has been granted, adverse to us, therefore we are coming here. No, it doesn't happen. And the judge may not know. So when they are, and then the party on the other side, because it is ex parte and not on notice, he wouldn't also know that there's already an order against him. It is at the time the order is either served or published that he gets to know. So the judge in Kebbi may not know what is going on in Anambra. However, the question to be asked again is, why go to a right emanates from an action in a particular state? The parties are probably resident in that state. The course of action is in that state. The parties maybe do business in a particular state. there's what we call territorial jurisdiction. Now, when somebody leaves such a place and goes yet to another state to obtain an order, was still an ex parte order, it gives room for suspicion, for concern. Because not only do we say that justice must be done, we must also see justice, it must also be seen to be done. So when a case comes up under circumstances like that, it gives cause for worry and concern. So,
Mr. Ogbole, you haven't quite answered my question. The question I'm raising is that if something is out of the jurisdiction of a chief judge, I imagine that chief judges man a certain jurisdiction. Isn't that correct?
Very well, very well.
Now, if this matter is of a conflicting nature, but it is outside of their jurisdiction, say not around the area that they man, do they really have powers? What powers can they exercise in that regard?
I thought I already answered that. No. What powers do they have? It is outside their jurisdiction. No. They can only concern themselves with their own particular state. Okay. That is why the NJC at the national level now is calling them all in, where it will be resolved. In the respective states, no. You can't leave your jurisdiction. You can't leave your state and begin to make pronouncements about the judiciary of another state.
But could they have called themselves before now? For instance, say the chief judge of Rivers alerts the chief judge of Kebbi, just painting a scenario.
That could be at the personal level. It could be at the personal level. For instance, like I said, judges may not know. It depends on how much they follow the news. They may not know. But once it is reported, when cases are reported, when judgments are reported, then it is taken that, yes, you would know. I mean, like reported in law reports. And oftentimes, most of them are usually in the Court of Appeal and the Supreme Court. They may not be immediately reported. So, yes, they may not know.
Okay. Let's quickly take the questions from my colleague in Lagos.
Well, thanks, Mark. I was going through some of the statements from the CJN at that meeting yesterday, and he was warning the CJs to henceforth avoid unnecessary assumption of jurisdiction in matters with similar subject and parties already before another court. In fact, he went on to advise all heads of courts to be current on the development in the polity and the judgments delivered by courts of various jurisdiction, and of course urgently issue practice direction to guide judges. And I know this has been, I mean, you've referenced this at least a few times during this conversation, but just to be clear, are you saying that judges, I mean, don't read the pages of newspapers? Because I mean, if the cases were brought to different courts the same day, it might be understandable, but one was taken to the Rivers courts one day, and a few days after, in fact, the news had broke on social media, online, on the pages of newspaper, before it was then taken to the other court. So does that imply that judges don't read pages of newspaper, they don't watch television, they just seclude themselves essentially from things happening in the polity? I hope you got me.
Judges read newspapers just like everyone else. They also follow the news. And there are some matters that are actually matters of notorious facts for which you could expect that people would know because, it's in the news and everybody talks about it and what have you. However, the responsibility of judges primarily is regards the matters that are specifically brought before them. The matters that are brought before them, they will first of all concern themselves with the matters, the applications that are before them. They are not likely to be influenced ordinarily by general sayings around the streets or what have you. They will first of all concern themselves with the matters that are before them. However, there are certain matters that are matters of notorious facts. Where there are notorious facts, it is also expected that judges, could take cognizance of such notorious facts in the administration of, in the course of administration of justice. So, we need to know the applications that are filed before these respective judges. So, unless we know the details of such applications, it may be difficult. Like I said earlier, in most cases, lawyers and applicants that file applications before judges, particularly ex parte applications, may not disclose entirely the facts, the full facts, before that court. it is possible that they will only disclose facts that could be favorable to them. But that does not in any way take away the fact that there are some matters that are notorious facts that are, if you like, public knowledge, for which courts may take cognizance of. At any rate, where we are now is where the judges themselves will have to answer to these matters. So when they answer to them, then we'll take it from there. We'll know, because the NJC will still have to decide, having heard all parties. So I expect that in the days ahead, they will come up with their answers and to all of these issues, and then the NJC will take its appropriate decision.
Well, on a lighter note, it means the judges have got to watch a lot more of maybe Sunrise Daily and News at 10 to get themselves abreast with some of those issues. But speaking seriously,
well, perhaps.
Yeah, I mean they have to, because for what the CJN has said, I'm not sure that they want to be on the wrong side of the law. Speaking about the law, is there any rule or any such thing that bars lawyers from forum shopping?
Well, in a way, yes, because one of the things that bars you is the fact that the rules of court provides for where a cause of action, where you can actually, the jurisdiction within which you can file your matter. For instance, the rules are clear in most of the high courts and, across the country and the Federal High Court, that the cause of action, where the cause of action arose, where the parties do business, or particularly the defendant does business, where the defendant resides. These three key elements are very, very important in determining where a matter is instituted. So there's what they call a territorial jurisdiction. So when a matter ordinarily emanates, or the parties there do business in a particular state, or the cause of action arose there, or they are resident there, and you take the matter from there to another jurisdiction, another state, that's a clear case of forum shopping. So yes, you would say that there are certain basic laws and principles that try to mitigate against forum shopping.
So in other words, if that kind of matter,
you may imagine a case like
go ahead.
Like the case of Ibori. In the case of Ibori, versus the Federal Republic of Nigeria, Ibori was resident for the material time in Delta. The offenses for which he was being charged were in Delta. The parties concerned, the funds concerned were primarily those of Delta State. But his action was commenced in Kaduna State, even though at the Federal High Court. But he went all the way to the Supreme Court, and the Supreme Court had to send the case back to Delta State for where the matter was again re-litigated. So yes, there are instances where people, even for political cases, more so for political cases, like the situation we have at hand right now, where you have conflicting cases from the respective, you see some coming up in one state, another coming up in another state, and what have you. But the rules are very clear, where you can actually, commence these actions, and the courts that ordinarily should have jurisdiction over this matter. So that's why you see the president of the Nigerian Bar Association, calling out and saying, look, what's going on? And the CJN is also saying, look, we need to wield the appropriate sanctions in appropriate cases.
So does that mean that
at the moment,
what we expect to see moving forward is that if certain cases of this kind of political cases come before the judge, they shouldn't hear it?
Well, the CJs of respective states, are empowered to come up with practice directions. And that's like the guiding rules operational in a particular state, in the High Court. So moving forward, it could be expected that the practice directions would be more stringent and would be, more clearly stated, so that it restricts your ability to take matters outside of the appropriate jurisdictions.
Would it be right for us to then assume that perhaps all those questions about technicalities, will be history?
Well, technicalities, you can't totally rule out technicalities in the practice of law and adjudication. But it is where technicality takes the day at the expense of justice that is a matter of major concern to the citizenry.
All right.
Okay, just follow up to some of the points you made earlier. So 3 judges essentially meant to show reason why disciplinary action should not be taken based on some of the cases we have seen those ex parte orders across the states. But do you think that perhaps we should have another solution, perhaps another layer of solution aside that one? Because this will also seem like a system issue if maybe there was some sort of, I don't know, the database or some system where you have real-time information on, you know, the cases that are, I mean, that particular case, perhaps it's in another court of coordinate jurisdiction. I believe you get what I'm saying. So do you think there should be another layer of solution such that it's not just focused on the judges who perhaps are saying, maybe this is a systemic problem. I mean, I can't be everywhere. I'm not omniscient or that. So do you think there should be another layer of solution?
Well, that is part of the evolution that, you know, and the improvements we hope to see in the course of time in the administration of justice. Using technology, like you said, information can be made more available, maybe at direct dedicated portals to judges and to particular jurisdictions, you know, across the states, so that you do not necessarily have to wait for a case to be reported either in the news media or in the law reports, which may take some time to come up before judges become aware. And again, practice directions moving forward, you know, in trying to cure this challenge that we have, can be targeted at actually streamlining issues of jurisdiction, not negating the fact of jurisdiction as provided for in the acts. So we can streamline that so that it reduces or narrows, it pinpoints where you can specifically, you know, file applications. And the sanctions also can also be improved upon. Now, the NJC is the body that appropriately looks into matters like this. That's why it is set up. And clearly the judiciary has its own internal mechanism, internal cleansing mechanism. So whatever the challenges are that we see, I trust that the judiciary, the NJC and the CJN, you would very clearly, using the instrumentality of the NJC, you know, appropriately address the matter to bring sanity to bear, so that moving forward, the confidence in the judiciary will further be strengthened.
I want to ask you about the body of benches, which a number of lawyers also belong to. Do you think that they have a role in this? Because it is not the judges who bring matters to themselves. It is lawyers who go forum shopping. Do you think that the body of benches can call lawyers to order?
Well, yes, I think so, but more appropriately, the MBA. Now, you have the MBA, you have the body of benches. The body of benches is more concerned with the legal education, the legal training, and, you know, the call to bar and the entire profession, as it were. But the MBA concerns itself with the practitioner. We all subscribe to it, and we have our own rules there. Now, don't forget, there's also the Legal Practitioners Disciplinary Committee that also takes care of disciplinary matters amongst lawyers. So these institutions do exist. So working hand in hand and the synergy between all parties, if they apply them properly, I believe that...
Do you think it should intervene in this matter? Do you think it should, or because the NJC is already on it, it should be left to the NJC?
Well, the NJC is more concerned with the judges. The MBA, the President Oluwapata, has already come up on the matter, and he has already called out, and from what I understand, he's already taken certain steps concerning that. You know, the lawyers who are particularly involved, I'm sure there are some discussions around them. So the details, I think, the President will himself say.
Okay. Yeah. Some judges, I must beg your pardon, some lawyers were a little, even though they were elated like you, they expressed mixed feelings. I mean, on one hand, they were elated. On the other hand, they also think that this could provide an inroad for an abuse of power if it's not checked. Because the point that they make is that this should not be construed as an opportunity to intervene or weigh in on the autonomy that judges wield when it comes to the judgments that they have given. and they fear that, you know, in future somebody could cite this example as some instance whereby a chief judge exercised powers that, you know, I don't know, they didn't have, perhaps, I don't know. But do you see any fear, do you exercise any fear whatsoever rising from this case that these powers could be expanded in future to, you know, to areas that were unprecedented in the very first instance?
I don't think so.
I hope you understand my question.
I understand you very well. I don't think so. Reason being that, one, first of all, ex parte orders or interim injunctions, as they are not total. They are not illegal. They are provided for in by our rules, and they are supposed to be exercised judiciously and judicially for the purpose of administration of justice. Now, what the CJN is doing, he's empowered to do it by the NJC Act. And all judges themselves are also bound by that act. Their conduct is also bound, must be in tandem with the act. Now, what the CJN is doing is not targeting any particular judge for a decision he took. He's looking at the totality of the institution. There are conflicted judgments here and there and there. And he has set up a machinery to look into it to find out. It's still a find because he has not taken any particular decision, to the best of my understanding. So unless a finding comes out, you cannot say that, you know, he wielded his stick. And besides, that does not stop them from, they all have their rights, even as a judge. So the fact that a matter is being investigated by the NJC does not affect the independence of the judge. It doesn't. Because if you are ordinarily, if you are challenging the action of a judge, you probably will be going on appeal. But in this particular instance, you have a multiplicity of diverse actions and decisions of courts. And you would not expect in good conscience that the CJN will sit and watch the entire institution. All over now, people look at the judiciary and people are wondering, what's really going on? You know.
So as a result of this action now, what outcomes are you expecting, and what significance do you think they will hold for the judiciary going forward, especially as we go into the political cycle?
Well, I expect sanitization. I expect that the process that has commenced will lead to greater sanity within the judicial.
By sanitization, what do you mean?
I mean a cleaning process whereby judges are conscious of matters that are brought before them so that they are not unduly led wrongly by lawyers who bring matters before them. Oftentimes, like I said, lawyers bring matters before judges and the judges do not know the facts of the matter other than what is presented before them in court. So by the time the CJN is done with this process, we expect, if there are mistakes, there are corrections to those mistakes. If there are things to be learned, people will learn. And there will be improvement in the overall system, whereby, justice is actually served to all concerned.
Well, I imagine that is the expectation of many Nigerians as well. We have to thank you so much for coming on Sunrise Daily this morning. Mr. Paul Harris Ogbole,
that's right,
is a senior advocate of Nigeria. Thank you for coming on
Thank
the
you very much,
program this morning. Well, we're not going to finish without taking your mails. We have a few of them. Let's look at this one from Mufutao Adewale talking about conflicting court orders. It says, conflicting orders by 6 high courts is absolutely ridiculous. It gives the common man low confidence in court orders and tarnishes the image of the judiciary. The negligent must be punished to avoid future occurrence.
Well, Abba Ali says, with the advent of technology, I suggest the NJC develop a portal warehousing database where all filed court cases will be uploaded as they are received, so that judges from all parts of the country can log on to view before entertaining fresh cases to avoid duplication of cases being filed in another court nationwide. It's doable and I believe can bring sanity and uphold the integrity of our judiciary.
Well, Festus Akiboyewa sends us a mail on the FG Nard face-off saying the tango between the two is uncalled for, especially when innocent Nigerians, patients, are the ones bearing the brunt.
Well, Henry says, talking about the NARD strike now, says the only hope is in President Muhammadu Buhari. Let us appeal to Mr. President to intervene directly on this matter and make pronouncements. This is an emergency.
Polycarp says the NARD president, in my view, is too political. He should tone down his personal attacks on the officials of government.
Well, take a look at famous Timile's mail, still on strike. It's a legitimate right of the resident doctors to strike and not a privilege. Parties should respect their agreement in the first instance.
And Kenneth Abiuro says, my appeal to all stakeholders in the health sector is this. While you're exercising powers or rights, please be humane. The deadlock between the striking doctors and the federal government is causing the deaths of many innocent citizens of the country.
And this one from Professor Inakena says the federal government must realize that healthcare sector is not only an important sector, it is also an indisputable and indispensable critical sector. Well, let those words sink in, I guess.
Yeah.
Well, I'm sure the words have sunk in. That's the show for today, everyone. Thank you for watching.
I think the VP who has intervened on this matter has also been appointed by the president as also I think the chairman of the Health Sector Reform Committee. So we look forward to see what will come of that, whether there will be an overhaul of the healthcare sector, but trust that we'll certainly keep tabs on it for you, any development in that particular sector. Thank you so much for watching this morning. I'm Ogbole Yusuf.
I'm Kayode Kikilu.
So guess we'll be hearing from the VP sooner rather than later then. I'm Chamberlain, so goodbye.